All right, we are live. I am just going to wait a little bit here to get started because I know there were a few people who had registered to watch this, and I want to make sure that people are given time to get access to the video before I start getting into the meat of the conversation today. So as I'm seeing people start logging in to watch the live, I just want to introduce myself. I am attorney Stacy Schlemmer. I am a family law attorney here at Peterson, Berk Cross. We have offices in Appleton and Green Bay, Wisconsin. I am licensed to practice law in Wisconsin only, so if anyone is watching this from out of state, sorry, but I don't know the other state's laws, and this might not apply to your specific situation. You probably want to consult with an attorney from the state where your case is located. I know that this is Lunch with a Lawyer, and my colleague Devin, who does these quite often, will typically have someone sponsor lunch and have a lunch to show off, and unfortunately I do not. So my lunch today is basically this delicious passion fruit flavored LaCroix. It's delicious. I highly recommend it, but unfortunately LaCroix did not sponsor this Lunch with a Lawyer. Hopefully you all have something more delicious to be enjoying over this lunch hour. So just as a disclaimer, I am an attorney and I am putting on this live event. However, this live event does not constitute an attorney-client relationship and does not give any attorney-client privilege. So anyone who's watching this, just a heads up, I am not your attorney simply by you watching this video, whether it's live or later as a recording. If you'd like to set up a free consultation with me, however, that is an option that's available. Simply give my office a call. It's 920-831-0300, and we can get a consultation scheduled on my calendar to discuss specifics that may be related to your case and questions that you may have, whether or not it's regarding anything that's covered in this live. So, getting into the topic for today, how to modify your family court orders. I want to touch base with you on this topic because it comes up quite often in family law, and I represent a lot of people who already have some sort of a custody, placement, or child support order, but they want to go back to court and change it. However, they don't know how to change it or what they can change or what would be required if they did actually file a motion. So first things first, with a motion to modify custody, placement, and or child support, the forms are available online for free if you wish to take a look at those forms and or fill them out and get them filed on your own or with an attorney. So if you want to take a look at what the forms look like, you can just do a simple Google search for Wisconsin Circuit Court forms. And the first link that pops up should be the Wisconsin Circuit Court Forms Bank. And in that Forms Bank, the courts have pretty much every form you could possibly need for any type of case in Wisconsin. So you would click on Family Forms, you would click on Post Judgment, because this is a motion to modify a previously ordered custody, placement, or child support order. And in that selection, there should be a motion to modify, and that's the form that you would be using. That's the form that I'm going to be referencing in this presentation. Along with that motion, there's also an affidavit that would need to be filed, and those two forms are available, like I said, on the Circuit Court website. If you just do a simple Google search, you should be able to find it. Now, if you hire an attorney to represent you, your attorney will likely be able to draft up a motion to modify and an affidavit without using the Circuit Court forms. So that's something you'd want to discuss with your attorney. Now, with a modification of custody or placement, and remember, custody is legal decision-making power, placement is the schedule. If you want to modify either of those issues in your order, that is covered by Wisconsin Statute 767.451. If you really want to do some fun reading, you can do a Google search for that statute and read all about modification of custody and placement orders so that you can get all of the information and details that I'm just going to be briefly overviewing today. So, with a modification of a custody or placement order, if you're looking at modifying the original final order in a divorce or paternity action within 2 years of when that final order was entered, there's a different standard that applies versus after 2 years has passed from the entry of the final judgment or order. So if you're within the first 2 years, the person who is looking to modify that order needs to show substantial evidence that there is a requirement or a need for the court to change the custody or placement order because there is harm to the child if the order is not modified. This is not an easy standard to meet. The courts did that on purpose. They don't want people changing their orders within 2 years if it's not absolutely necessary. So if there is physical or emotional harm to the child or children, then that would be something that you could bring up to the court and you would want to put into your motion if that's a reason why it needs to be changed within the first 2 years. So along with showing harm to the child or children, you also, of course, need to show that it's in the best interest of the child or children, which if there is actually harm being done to the kids, it goes without saying that it would be in the children's best interest to change that order since harm is being done. But that is what you need to keep in mind when you're getting a final judgment or order on placement or custody, is that there is this 2-year waiting period basically, or prohibition period, where you need to show a much higher standard in order to try to modify the custody or placement schedule. Now, after 2 years has passed from the date of your original final order, then you simply need to show that there's been a substantial change in circumstances and that it's in the child or children's best interest to have the custody or placement schedule changed. Now, keep in mind, under the law, there is a presumption that maintaining the status quo is in the child or children's best interest. So if you currently have an order that says that the parents have joint custody and you want to try to modify that, the court is already going to be presuming that keeping it at joint custody is going to be in the kid's best interest. So it's your job in trying to convince the court that the modification needs to be done to show the court why it's in the children's best interest to modify it rather than maintaining the status quo. So you would need to show examples where the other parent wasn't complying with the custody or wasn't communicating with you, things like that. The same would go for placement. If you have an equal shared placement schedule now and you're trying to modify it to get primary placement, you need to show the court why the presumption should be overcome that it's in the best interest to maintain the 50-50 equal placement schedule. It happens all the time, but just be aware that that's something that you're going to need to overcome if you're the parent asking for the order to be changed. So there are some different items that the court can change without needing the substantial change in circumstances or harm to the child provisions to be met. Some examples of those are the court can modify a placement schedule that doesn't substantially change the placement time between the parents if it's in the child's best interest without any regard for the need to show substantial change in circumstances or harm to the child, things like that. So that's something to keep in mind as well. If you simply want to change which overnight a parent gets, say they normally have Monday overnight and you want to change it to Thursday overnight, and it doesn't change the amount of time that the parent has with the child, it just changes the day that the parent has the child, that would be an example of a request to change that does not substantially change the amount of time of the placement schedule. Hopefully that makes sense. Another example is the court can modify a placement schedule if the petitioning parent shows that the other parent just fails to exercise their placement time. So, for example, if the parents are awarded equal shared placement and one of the parents just simply does not exercise any of their placement, or maybe exercises placement 1 day out of every 50 days that they could be exercising their placement, that would be another example where the court could bypass the 2-year prohibition period or the substantial change in circumstances test in order to modify a placement order. Additionally, the court can deny placement to a parent if the parent endangers the child's physical, mental, or emotional well-being. So as the petitioning parent, you would be the parent to show how this is being done. It isn't something you can simply just allege and throw out there. You're going to want to have some sort of documentation or evidence to provide to the court to show why you feel that this danger exists, or examples of abuse that has been done, or if this person has been maybe convicted of child-related criminal activity or domestic violence or something where you feel very strongly that this child or the children are in danger or their health is in danger. Those are examples where the court can kind of bypass, if you will, the requirements for the 2 years to pass before getting rid of the harm to the child standard and for substantial change in circumstances. So when any parent files a motion to modify custody, placement, or child support, the courts require you to specify why you're requesting the change when you file your motion. So if you take a look at the forms that I referenced earlier, there will be the motion form and then there will be an affidavit. And the affidavit, that's just a fancy word for sworn statement. So that's a statement that you would write up and then you would sign that in front of a notary, meaning that's sworn to under oath, and it would be punishable by perjury if you, as perjury I should say, if you lie in what you say in that document and you're signing your name in front of a notary public. So you want to make sure that you are truthful in what you are saying in your affidavit to the court as to why you feel custody, placement, or child support order needs to be modified. That is a requirement by the court. And that is simply to provide the other parent with notice of what's being alleged, so that when you go to court, everyone is on the same page with what is being requested and why it's being requested. There's also, in many counties, they're going to require a parent to file a proposed parenting plan with the court stating what they want the custody or placement schedule to look like. So that's another form that's available online. If you do the same Google search in the same area of the forms bank, you should find a document called Proposed Parenting Plan. I believe it's about 5 or 6 pages long, and it'll lay out, it's basically a fill in the blank of different things that you need to be considering for what you want the custody and placement schedule to look like. So you want to take a look at that, have one ready to go in case the court asks for it. You may also want to check your local court rules, especially if you don't have an attorney representing you, to see if your local court requires that you file a proposed parenting plan. You don't want to show up for court and then have the court either dismiss or adjourn your hearing because you didn't file something that you're required to file under the local court rules. It also, by filing that proposed parenting plan, you're giving the court an idea of what you're actually looking at have happen. If everything goes exactly how you want it, your proposed parenting plan lays out what you believe the whatever it is, custody or placement should look like. It might actually help you to think through all of the details that maybe you didn't think through in just filing a motion to modify. There's going to be provisions in there about the holidays, about vacation, about who's taking the kid to school, things like that. So it's a good idea to actually look at that form and fill it out before you have your hearing. With a motion to modify, the court is typically going to require parties to attend mediation through the respective county before they will move forward with appointing a guardian ad litem to represent the minor child and do an investigation and provide feedback to the court. So something you might want to consider is before you even file a motion to modify, attempt mediation through the court so that when you go to your hearing and say you go to mediation in July, you file your motion because mediation was unsuccessful, you have your hearing in August or September, you could tell the court, hey judge, or hey commissioner, I'm filing this motion to modify placement because this isn't working. Mom's not seeing the kid at all. I have all of the placement time and this needs to be modified. We already attempted mediation. Mom doesn't agree. We reached an impasse. Please just move forward and appoint a guardian ad litem. You have a much better shot at bypassing mediation if you just attended within the last month or two. And you can show the court that the issues that you discussed in mediation are the same issues that you're bringing up in your motion. It's an easy way to kind of save time through the court process. And it's something that I will often recommend to my clients just to try to, move things forward faster once you have your motion filed with the court. Plus, that way, if you do go to mediation and you reach an agreement, you didn't even have to file a motion to modify if you did the mediation ahead of time. So it's an easy way to save some costs there too. So hopefully that gives you a little bit of an overview of what you have to do in order to file a motion to modify, where to find the motion to modify, and then what some consideration should be that you're taking into account when you're filing, or maybe before you file, such as trying mediation first. If anyone has any questions, feel free to comment. I know last time I did one of these, I wasn't getting any notifications of messages. So I just want to double check and see if I'm getting any messages that I can see anywhere. So I'm not seeing anything. I'm going to wait and see if there's a delay here and see if anybody's posting that I just haven't seen yet. If anyone has questions, feel free to post in the comments. Otherwise, if there are specific questions you have about your case and you don't know if you have a good enough case to really file something, or if you want some feedback on what the court may or may not do, or what the court's going to require, a lot of that can depend on what county you're in, what commissioner you're in front of, or what judge you're in front of. So the family law attorneys at this office, not only me, but also Attorney Angela Bolter and Attorney Devin Stanley, we all have a lot of experience in family courts all over the state, really. So we can give you some feedback on, oh, you're in front of Judge so-and-so, this is what Judge so-and-so likes to see, or this is what this commissioner or judge typically does. So if you want something different, you might want to think about doing X, Y, Z. So, a question, how do I hire an attorney to help me modify an order? So, well, you can watch a video like this and get introduced to an attorney like myself, and schedule a free consultation if an attorney that you're interested in meeting with offers one. I know that there are some attorneys in town who charge for a consultation. It's up to you if you want to be charged or just go to a free consultation. It shouldn't make any difference in the value that you're provided in a free consultation, but that's a good way to kind of feel out different attorneys to see who you click with. When you're dealing with family court, you really need to be comfortable with the attorney you're working with, because these are really important, if not the most important decisions that are ever going to be made in your life, because it can concern how often you see your kids. And I can't think of many more things that are more important than the time you spend with your kids. So it's important that you click with your attorney, that you trust your attorney, and that you trust their advice. So it's a good idea to either set up consultations or look at reviews online and see who you might be comfortable with. If you wanted to work with our office, you just give us a call. We would set up a consultation, and then we would go over what's required of you, what's expected of us, how we do our billing, what the fees are. All of that can vary depending on the type of case, where you're at with the case, and what needs to be done. So that's my kind of long answer to a pretty simple question. How do you start the process of going to mediation? That's a good question. So in most final orders, whether it's a paternity case or a divorce case, there should be language stating something along the lines that if a dispute arises in the future, the parties shall attend mediation through the county before filing any motions or something like that. A lot of people don't actually go to mediation first before filing a motion, even though it really is a good idea. If you want to pursue mediation through a county and you don't have a pending motion that's already been filed with the court, you can just contact the mediation department for that county. And if you can't find their phone number online, you can always call your county's clerk of court's office and ask them for the phone number. And I've never run into an issue where the clerk of courts has been unwilling to provide the number for mediation, because the hope is that more people will attend mediation and reach agreements, and they won't need to file as many cases because things will be resolved in mediation. Now, if you already have a motion filed and you're scheduled to go before a commissioner or a judge on your motion, then usually at that first hearing, if the court finds that there's a reasonable basis and that you've met the burden of a substantial change in circumstances and or harm to the child or what have you, the court will order you to mediation. So you don't have to worry about requesting it outside of a court order. But there are a couple of different ways that the court can look at that. So you might want to talk to your attorney to see what way is the best way for you. If you have a domestic violence situation or a restraining order in place or something that would keep you and the other parent from being able to do mediation, where you're in the same room together with a mediator, you would want to let the court know that, and you would want to let the mediators know that, so that A, you can either bypass mediation and go directly to a guardian ad litem, or B, you can see if the mediator is able to set up mediation where you're in one room and the other person is in a completely different room, so that you never have to actually interact and be in the same room together. If that is not an option that you're comfortable with, that's where you would just file your motion and request appointment of a guardian ad litem without needing to go through mediation. And as long as there's a domestic violence situation or a restraining order in place, the court is going to allow that bypass of mediation. All right, in terms of changing child support, someone once told me that every so many years, the child support office will offer the primary placement parent a review of the non-primary placement parent's income. Is that true? Well, it depends on a couple of things. If there's state assistance involved, the child support office will stay involved on the case. They may not be monitoring it very often, but they will check in on things because they have skin in the game, so to speak. If the state is providing benefits, then the child support office, which is the state, wants to make sure that the non-primary placement parent or the person paying child support is staying up on their child support and that it's the proper amount. So they're going to schedule reviews usually every 2 years. It might be more or less than 2 years, depending on what the child support office decides to do. However, if there are not state benefits being provided, there's no food share, daycare assistance, things like that, then it is very unlikely that the child support office would ever on its own pursue a change in child support or a review of child support or try to get the parties to exchange information. So that's why it's important for parents who have a child support or maintenance order to make sure that you're following what's in what should be all orders to exchange your tax returns every year, so that you're always up on who's making what, so that if you need to change the child support or you want to request a modification of a maintenance order, you would have documentation of what the other person is earning as justification to modify that order. If you're not exchanging your tax returns, then you don't get the notice that you may need of a change in income to be able to modify or even know that you should be requesting a modification of a child support or maintenance order. Now, if you get tax returns or pay stubs from the other parent and you don't know if you should pursue a modification, or you don't know how to run the different calculations to know what child support would look like, that's something that you can always talk over with an attorney in a consultation. Some attorneys, like myself, will offer limited scope representation, or if you just want to hire an attorney to review and run some numbers and discuss those with you, give you options, give you some basic advice on that limited issue, and that's it. That's the only thing you hire the attorney for. That would be a good option as well if you don't want to spend as much with coming up with a full retainer and having an attorney represent you from start to finish. You can always look and see if there's someone who would do a limited scope representation to give you some advice and run numbers for you and give you some feedback. Are there any other questions out there? that anyone has about anything. I'm more than happy to answer any questions about modifications. Okay, so I'm not seeing any more questions popping up in the comments. So for right now, we're just about out of time anyway. So just a reminder, if you're watching this live or if you watch this later on a recorded version, if you have any specific questions or even general questions, you just want feedback from an attorney, you can feel free to call me or either of the other family law attorneys at Peterson, Berk Cross, and we'd be more than happy to set up a free 30-minute initial consultation. We can go over any questions that you have and give you general information about what your rights and options might look like, or things that you might want to consider doing or not doing in the future to help you with your case and with your kids. So if you wanted to set up a free consultation, again, just give our office a call. It's 920-831-0300. Oh, and I just saw one more question come up. What if your spouse loses a job? So if that's, I'm guessing it's former spouses, we're talking about modification orders. So if you have a child support order or maintenance order in place and the person paying child support loses their job, or if it's a shared placement but you're considering both parents' incomes and one of the parents loses their job, it's a difficult situation. The court will look at a few different things on whether they're going to modify the child support order or not. Just because a parent loses their job does not mean that the child support order automatically changes or goes away. The reason being is if someone was smoking in their office and they're not allowed to smoke in their office, and because they smoked in their office they lose their job, well, that was that person's voluntary decision to violate the rules and they got fired for it. That doesn't mean that they should be off the hook from paying child support. It wasn't as if a company downsized and they had no control over it and lost their job. That's a completely different situation. The court's going to want to know why that person lost their job, if it was reasonable, if they're making efforts to try to get a new job or what they're doing, if they have any sort of unemployment coming in, what are their sources of income. Those are all things that the court can look into as well. So if someone loses their job, normally it would be the person who loses their job who would be filing a motion to modify, because they're likely going to claim that their income has gone down or gone away completely and they need to modify the order because they can't keep up with their child support and maintenance payments. It could be the other person if the payer just stops paying because they lost their job and there's not paying any support, then there would likely be a contempt motion being filed by somebody because there's non-payment. But in terms of a motion to modify, usually it would be the person who loses the job, and then they would need to show that they're making reasonable efforts to try to get a new job, to earn at least what they had been earning before, things like that. If someone isn't taking those steps and they're not trying to get a new job or make what they had been earning previously, things like that, the court can impute income to someone who isn't actually earning that amount, but is capable of earning that amount. So, for example, the question was about someone who loses a job, but even if someone, say, is a CEO making $100,000 a year, and then they leave that job voluntarily and go to work at McDonald's flipping burgers for whatever they get paid now, $10, $12 an hour, they can't tell the court, well, they can tell the court, it doesn't mean the court's going to do anything about it. They can't claim that they can only make $10 to $12 an hour at McDonald's when they just left a job as a CEO making $100,000 a year. The court in that situation would likely look at that and say, well, you're capable of making $100,000 a year. There was no reason for you to quit. You voluntarily left that job. We're going to impute $100,000 a year to you for purposes of calculating child support or maintenance or whatever the situation is. Doesn't matter if you're actually making $10 an hour. If you're capable of making $100,000 a year, that's what you're imputed, and that's what you're going to be paying child support based off of. So that's an example of how the court can look at that type of a situation. And that does factor in with both maintenance and child support. Even if someone isn't making what they could be making or are capable of making, the court can still impute that income to someone else, the court can look back at Social Security earnings statements to show what the payer had been earning in all years that they've ever had a W-2. That's an excellent, or I should say filed taxes, that's an excellent way to get income information for someone, is their Social Security earnings statement. And that's something you can request in discovery if child support or maintenance is on the table. The other thing that the court will look at is not only their income earnings history, but what their training is, what their education is. The court can order, or a party can request the other party to undertake a vocational evaluation, and that's where a vocational expert will actually meet with the payer and go over their educational history, their work history, the earning history, and figure out what that expert believes the payer is capable of earning based upon their history, their situation, and what the job market looks like in whatever area you're in. It's a great option out there for people who want to get an idea and have an expert available to testify in court as to what someone is capable of earning. So in the example of the McDonald's person, this would be a situation where I would 99% of the time recommend a vocational evaluation, because you know that the person is capable of earning more than $10 to $12 an hour flipping burgers at McDonald's, because you know that in the past they worked as a CEO, or say they went to Harvard Business School and they have all this training and these great degrees and they're not using them. That would be a prime example of where you'd want to request a vocational evaluation to ascertain what that person is actually capable of earning, and then you would ask the court to impute that income for purposes of a modification or even an original order for custody, or I'm sorry, for child support or maintenance. If someone consistently loses a job, the court can take that into consideration. If it's because of the employee's actions and it's shown to be purposeful to try to limit their earning capacity or income, then the court will consider that. If there are legitimate reasons for the person to be leaving these positions for whatever reason, the court can consider that too. So it really comes down to what that specific situation looks like. Okay, so we are actually, it's past 12:30, so I'm going to let you guys go. But like I said, if you have any other questions, feel free to message me on Facebook or give us a call, set up a free consultation. We're more than happy to talk with you, 920-831-0300. All right, have a great rest of your week and rest of your Thursday. Bye.